Hi, Mike Hoogbruin here. I'm a Vancouver personal injury lawyer. I'm blogging today to give you a summary of a recent Court of Appeal decision that might be of interest. This is a case involving a lady who was driving her car in December 2009 in the city of Surrey when she skidded on some ice and crashed into a concrete pillar surrounding some gas station pumps, and had some injury. What's of particular interest here is that the city was found partially responsible for failing to properly maintain the roads, and she, the driver, was found partially responsible as well. So the facts are, back on December 14th, 2009, the plaintiff, that is the person that was injured and brought the lawsuit, Ms. Rhodes, was driving to work on a cold morning westbound on 80th Avenue in the city of Surrey. As she was approaching the intersection at 192nd Street, which had a four-way stop, and she was traveling, the evidence suggested, between 25 and 35 kilometers per hour in a 60 kilometer per hour zone. She applied her brakes and then slid into the Mountain View Market concrete pedestal on which gasoline pumps were located. Interestingly, just prior to the accident, several other drivers had passed through that area without crashing, although one driver did skid but managed to retain control. And in terms of the city's responsibility, the city of Surrey had, prior to the accident, distributed anti-icing brine on the road, sort of a salt mixture. But a refreeze occurred because the brine was overwhelmed by additional snowfall. And the city had failed to follow up with plowing and salting to prevent the refreeze. So by the time the plaintiff arrived at that area, the roads were already again pretty slippery from the refreeze. As a result of colliding with this concrete barrier, Ms. Rhodes was injured, and her primary injuries were psychiatric disorders, including a somatic system disorder, a post-traumatic stress disorder, anxiety disorder, and depression. She also suffered injuries to her vestibular system and balance mechanism. I won't here go into an in-depth explanation as to what all those different disorders are, but they can be quite severe, and in this case for Ms. Rhodes, they were disabling, meaning that they prevented her from continuing with her work. Ms. Rhodes' personal injury lawyer that tried the case tried it in the British Columbia Supreme Court with a judge and a jury. Now, in British Columbia, people who are involved in lawsuits that involve motor vehicles and certain other types of claims have an option. You can have your case tried or heard before a judge alone or with a judge and a jury. In this particular case, the parties elected to go with a judge and a jury. And in that situation, that's probably more commonly what you've seen on TV, where you have a judge who makes determinations on the admissibility of evidence and makes determinations and guides the jury on what the appropriate law to be applied to the case is, but the jury is responsible for making findings of fact and ultimately deciding the real conclusion of the case, and that is what, if any, would be the appropriate compensation for a plaintiff in a particular case. In this case, for Ms. Rhodes at the end of 22 days of trial, and that's a long trial, 22 days. The jury awarded $100,000 for pain and suffering, past income loss of $305,000, and that past income loss means income loss from the date of the accident to the date of trial. Future income loss in the amount of $1,085,000, and future income loss means money from the start of trial to the future going forward until when the jury decided that the income loss ended, probably at Ms. Rhodes' anticipated retirement date. Special damages in the amount of $45,000, and special damages is just legal talk for out-of-pocket expenses, which most likely were medical expenses that Ms. Rhodes incurred on her behalf. The jury also awarded cost of future care, which is again mostly future medical care that she would require, in the amount of $1,955,000. As well, reimbursement for the Ministry of Health medical expenses incurred to the date of trial, $36,600, and what's called an in-trust claim for medical care provided by a loved one in the amount of $50,000. So presumably there was someone who assisted Ms. Rhodes a great deal, to the point where the court thought it appropriate that person be reimbursed for the time spent caring for Ms. Rhodes. So the jury quantified the total damages, and damages is just legal talk for money, quantified the total amount of the value of the case at $3,576,600, so around $3.5 million. However, that's not what Ms. Rhodes received. The jury also found that Ms. Rhodes was 75% responsible for the accident, with the city of Surrey being 25% responsible. As well, the jury found that Ms. Rhodes was 75% at fault, if you will, or that her damages should be reduced by 75% for failing to mitigate. And what that means is the jury determined that Ms. Rhodes should have followed medical advice that likely would have reduced the consequences of the injuries, and because she failed to do so, the jury said her award should be reduced by a further 75%. So there were two 75% reductions. One for what's called contributory negligence. In other words, she was 75% at fault for the accident, the city of Surrey 25%, and a further 75% reduction for not properly following medical advice. So the jury found that the original $3.5 million, once you take the two 75% reductions, would be reduced to $223,537.50. Now, Ms. Rhodes appealed that jury verdict to the British Columbia Court of Appeal, arguing that the jury erred or made two mistakes. The first argument was that the jury erred in finding Ms. Rhodes 75% responsible for the accident, and further for finding that her award should be reduced by 75% for failing to mitigate. The Court of Appeal heard the appeal and decided that there was no error with respect to the jury's finding of contributory negligence. In other words, the Court of Appeal found that the jury did not make a mistake on that issue, and so the jury's determination that Ms. Rhodes was 75% responsible for the accident and the city of Surrey 25% responsible, that verdict stayed. However, the Court of Appeal said that the court below did make an error in finding that Ms. Rhodes failed to mitigate her damages. The Court of Appeal said there was insufficient evidence on this point, and that the defendant, in this case the city of Surrey, had not satisfied the onus on it to establish that Ms. Rhodes failed to properly follow medical advice, and further that if there was medical advice that she should but didn't take, that it would have reduced, or likely would have reduced her damages, or in other words, there was no medical evidence that Ms. Rhodes did anything other than what was reasonable to try and get better. So that second 75% reduction was discarded. So just to summarize, the Court of Appeal at the end of it said, yes, Ms. Rhodes was 75% responsible for the accident, but no, the case should not be reduced for a further 75% for failing to mitigate. So once you take into account the Court of Appeal's reversal in part of what was done below, Ms. Rhodes will be entitled to approximately $1 million in total. So that summarizes that case, I think, for you. I guess the takeaway message there is, if you're in a single vehicle accident in the Lower Mainland or anywhere in British Columbia, that doesn't necessarily mean that your case is over. There could be responsibility on, say, for example, the city or the province if they fail to maintain the roads in proper condition. And in this case, for the city of Surrey, although they initially laid down some salt, they had failed to follow up when they should have in terms of plowing and making sure that the road was safe for people using the roadway. Another takeaway, of course, in this is a reminder that, and it almost goes without saying, but you should follow the advice given to you by your doctor and do it diligently to try and get better. Or if you don't, there will be an allegation by the defendant or the insurance company on behalf of the defendant that you didn't do everything reasonable to try and get better, and that your compensation should be reduced for what's called failure to mitigate. With that, I think I'll end my little talk today and hopefully talk to you again sometime in the near future. Thank you.